Welcome to the debate. So, imagine someone steals your wallet.
Okay. Terrible start to the day, but go on.
Right. It's a nightmare. Now, to get your money back, the legal system requires you to prove not just that your wallet is actually gone, but exactly which street corner the thief spent your cash on.
Oh, wow. Good luck with that.
Exactly. And you need official third-party receipts to back it up.
Which is, essentially impossible for an average person.
Completely impossible. But that dynamic is, it's essentially the exact challenge facing 35.8 million Xfinity customers right now. We're looking at a landscape of harm that is incredibly difficult to quantify.
It really is. It's a fascinating problem, honestly, because you are dealing with a digital asset, right? Personal data.
Right.
And that data doesn't just disappear when it's stolen. It's just copied, it's distributed, and monetized in the shadows. And yet our legal system basically forces us to try and price that invisible harm.
It forces a physical world standard on a digital problem, which brings us directly to our focus today. We're looking at the October 2023 data breach affecting all those Xfinity customers. Comcast publicly disclosed the breach in December of 2023.
Right. Which immediately triggered the massive class action lawsuit, Hassan versus Comcast Cable Communications, LLC.
Exactly. So we are looking at the current reality of how this is actually being resolved. There is a $117.5 million settlement fund, and it's currently open for claims right now ahead of the late summer 2026 deadlines.
Yeah, the final approval hearing is scheduled for July 2026, and there's a hard absolute claim deadline of August 14, 2026.
Right. So our central debate question today is this. Does the dual-tiered structure of this settlement function as a precise, fair mechanism for consumer restitution?
Or is it fundamentally a liability shield designed to minimize corporate payout through, prohibitive administrative barriers?
Exactly the tension we need to explore. And I'll state my position up front. I hold the perspective that this settlement is a highly rational, evidence-based model. It deliberately protects the fund for those who are truly harmed, while offering a proactive defense for everyone else.
And I look at this from a completely different angle. I argue that the burden of proof baked into this agreement renders the highest compensation tier largely inaccessible to the average victim.
You think it's too high a bar?
I do. Ultimately, I think this structure serves the corporation's balance sheet far more than it actually serves the consumer.
Well, let's lay out the foundation of these positions before we dive into the deep mechanics. When I look at the architecture of this $117 million settlement, I see structural soundness. It is mathematically responsible.
Mathematically responsible for Comcast, maybe.
Well, for the fund itself, the highest tier of compensation allows class members to claim up to $10,000 for out-of-pocket losses and up to 5 hours of lost time, which is compensated at $30 per hour.
Right, up to 10 grand? On paper.
But crucially, that top tier is reserved for those who can empirically prove their losses with what the settlement explicitly defines as reasonable documentation. We are talking about official bank statements, credit reports, invoices.
Hard paperwork.
Yes. And that strict evidentiary standard is absolutely necessary. It prevents fraudulent claims from just completely draining the fund. For everyone else, the alternate is a $50 cash payment and an automatic 3 years of SciEx Financial Shield complete.
Which sounds very comprehensive when you list it out like that.
Because it is. That dual system provides immediate, frictionless relief and a digital firewall for the broader base of affected consumers. And it does that without bankrupting the restitution pool.
Okay, you outline the logic well, but we have to consider how those requirements actually play out in reality. Because that $10,000 figure is, for the vast majority of those 35 million victims, an absolute mirage.
A mirage? How so?
Look at the nature of what was exposed here. We're talking about highly sensitive data. Partial Social Security numbers, usernames, passwords, contact information.
Sure, it's a serious data set.
It's extremely serious. But the settlement erects this massive administrative barrier. It requires users to prove that their specific instance of identity theft or fraud is fairly traceable to this exact October 2023 breach.
Which is the legal standard of harm.
But it explicitly rejects self-prepared documents, like handwritten receipts. So the inevitable result of this structure is that most victims will just abandon the process entirely. They'll default to the $50 alternative payment.
If they don't have the proof, yes.
And that $50 is subject to pro rata reductions, meaning it will likely be far, far less. This setup allows Comcast to efficiently extinguish its massive liability, admit zero legal wrongdoing, and walk away with absolute certainty over its financial exposure.
I see why you view the documentation requirements as a prohibitive barrier. But let's move from the headline figures into the actual mechanics of claiming that top-tier restitution, because I view those requirements as a necessary gatekeeper, not a wall.
A gatekeeper that locks almost everyone out.
Let me offer an analogy to explain why it's necessary. Think of this settlement fund as a communal insurance pool. If we do not demand hard proof, things like notary fees, mileage records, credit card statements, for a $10,000 claim, aren't we just incentivizing perjury?
Well, I wouldn't say incentivizing.
If all it took was a handwritten note saying, hey, I lost 10 grand because of this breach, the entire pool would be drained in a week by bots and bad actors.
That is a risk, yes.
The victims who actually suffered severe, verifiable identity theft would be left with absolutely nothing. The money would be gone.
You make a fair point about the risk of fraud, and I don't disagree that a communal pool needs protection. But your analogy assumes a level playing field.
In what way?
It assumes an ordinary person actually has the ability to trace the origin of their digital harm. Let's talk about how this data actually moves on the dark web. Because the epistemic reality of a data breach makes that tracing almost impossible.
It's difficult, but not impossible.
When a threat actor steals a database, they don't just use it directly. They sell it to data brokers in the criminal underground. Those brokers cross-reference your Comcast data, so your partial social security number, your passwords, with data from an old Equifax breach, or maybe a healthcare provider leak.
Right, they aggregate it.
Exactly. They create a complete profile, which is called a FULS. Now, the settlement demands that your financial loss be fairly traceable to the Comcast breach that occurred between October 16 and October 19, 2023.
Which is the specific window of liability.
Right. But if someone files a falsified tax return in your name in, say, 2025, how do you definitively prove to a claims administrator that the bad actor bought the Comcast piece of your profile rather than the piece leaked by your health insurance company?
You use contextual clues, timing, email addresses used.
But the friction is entirely placed on the victim to prove a negative. They essentially have to disprove every other breach they've ever been caught up in.
I completely understand the complexity of data aggregation. It's a mess. But the legal standard here is fairly traceable, not exclusively caused by.
That's a very fine line for a layperson to walk.
But there is a vital legal distinction there. The claims administrator isn't asking for a cryptographic chain of custody. They're looking for a reasonable, temporal, and logical connection.
But what does that look like in practice?
If you get a notice that your data was breached in December, and then in January someone opens a credit card in your name using the specific email address associated with your Xfinity account, that establishes a fairly traceable link.
Okay, but look at the lost time provision within that same tier. Let's say you do manage to trace it perfectly. The settlement allows you to claim up to 5 hours of lost time at $30 an hour.
Right.
That is a maximum payout of $150 for your time. Have you ever helped someone unwind a stolen identity?
It is an incredibly difficult process. Yes, I have.
It is a grueling, dozens of hours long administrative nightmare. You are on hold with credit bureaus, you are filing police reports, you are contesting charges with multiple banking institutions.
No one is denying it's an awful experience.
But capping the compensation for that specific agony at 5 hours severely undervalues the real human cost of inadequate data security. It basically assumes the resolution of identity theft is a swift, linear process, which we know is demonstrably false.
You're absolutely right about the profound friction of unwinding identity theft. But the reason that friction exists in the settlement, the reason for the cap, is rooted in administrative scale.
Scale shouldn't erase actual damages.
The 5-hour cap isn't meant to represent the totality of the worst-case scenario. It is a standardized metric. It's designed to offer a streamlined payout without requiring a formal deposition.
So it's for efficiency?
Think about the mechanics. If you had to prove exactly how many hours and minutes you spent on the phone submitting phone logs, matching them to bank dispute timelines, the administrative costs of verifying those complex claims would eat up the very settlement fund we are trying to protect.
I see the logistical argument there.
The system requires standardization. By setting a 5-hour cap at $30 an hour, the administrator can efficiently process claims and actually distribute funds to people.
But again, accessing even that basic level still requires reasonable documentation, and the settlement explicitly states that self-prepared documents are insufficient on their own. So we have to ask, who does that penalize?
It penalizes people without formal records.
Exactly. It penalizes the unbanked. It penalizes people who don't have sophisticated personal filing systems. It penalizes the working class who might be paying out of pocket in cash to deal with the fallout of their compromised data.
But
The barrier to entry for the top tier is fundamentally skewed toward those with the resources and the financial literacy to maintain a pristine administrative paper trail.
I hear that concern, I really do. But what is the alternative mechanism? If you accept handwritten receipts as primary evidence for a $10,000 payout from a corporate settlement fund, the vulnerability to organized fraud is catastrophic at this scale.
It's a risk, but
You wouldn't just have disorganized individuals applying. You would have coordinated bot networks submitting tens of thousands of fake handwritten receipts. Relying on official bank statements and credit reports is the only empirically sound way to distribute money safely.
okay, well, if we accept that the $10,000 tier is structurally out of reach for a massive portion of the working class, then we have to logically look at what is behind door number 2.
The default tier.
The default tier. Because of the sheer difficulty of proving direct traceable harm, the vast majority of the 35.8 million effective customers are going to default to the $50 alternative cash payment.
And you see that as a failure of the system, whereas I see it as a pragmatic, frictionless option. If you are listening to this, you've probably gotten one of these emails yourself at some point.
Oh, we all have. Many times.
Right. You see data breach settlement in your inbox. You realize you haven't suffered a specific financial theft from this particular incident, so you opt for the simplest route to compensation.
But the compensation is a mathematical illusion.
How so?
Let's look closely at that $50 figure. We need to define a crucial term here, pro rata adjustment. The documentation explicitly notes that the $50 is just an estimate. It is subject to a pro rata distribution based on the number of claims.
Which is standard for fixed fund settlements.
Yes, but think of a pro rata distribution like a single pizza. If 10 people show up to the party, everyone gets a decent slice. If 1,000 people show up, you're getting a crumb.
The fixed fund dilutes as participation rises. That's just math.
For up to 1/3 of that fund in attorney's fees.
Right.
That is $39.17 million straight off the top. Then you subtract the litigation expenses. You subtract the service awards for the class representatives. And then there are the massive administrative costs of physically notifying 36 million people and setting up servers to process their claims.
Which, again, is standard overhead for a class action of this magnitude. The infrastructure required to simply send secure emails to 35.8 million people is immense.
Standard, perhaps, but it rapidly shrinks the pie. You are left with a net settlement fund that is roughly half of the headline number.
Okay, let's follow the math.
Let's say we have $60 million left. Now, divide that remaining net fund by any significant portion of the users who might actually file by the August 2026 deadline.
Okay.
If even 10% of the class, so 3.5 million people, files for the alternative cash payment, that 60 million divided by 3.5 million people means the pro rata payout is closer to $17.
$17 instead of $50?
Right. And if 20% file, it drops below $10. The $50 is dangled as an incentive, but the mechanics of the pro rata distribution ensure that if people actually participate in the settlement, the individual cash reward evaporates.
I understand the mathematics of a pro rata dilution, and you're correct that high participation lowers the cash payout. But I think you are artificially isolating the cash and ignoring the most substantive part of the default tier.
You mean the credit monitoring?
Yes.
The settlement structure heavily redirects focus to the non-cash benefits for a very specific reason. Every single class member is entitled to 3 years of SciEx Financial Shield, complete.
Which sounds like a buzzword.
Well, let's explain what that actually is. We are talking about one bureau credit monitoring, dark web monitoring, real-time authentication alerts, high-risk transaction monitoring, and most importantly, a $1 million identity theft insurance policy.
A suite of services they have to proactively enroll in, using an activation code that they'll probably lose in their spam folder.
Yes, they have to activate it, but the underlying value of that service is profound. I frame this not as a mere perk, but as a proactive digital firewall for millions of people.
But is it actually restitution?
Think about the corporate economics here. If Comcast had to go into the retail market and purchase 3-year licenses of comprehensive identity defense for 35 million people, the cost would astronomically exceed $117 million.
Sure, the retail value is high.
Providing real-time monitoring is a far more substantive form of restitution than any one-time cash check. A small check is retroactive. It pays you for a hassle you already experienced. The SciEx Shield is proactive. It actually hardens the consumer's digital perimeter against the very data brokers you mentioned earlier.
But let's ground this in the listener's reality. Let's look at how these corporate credit monitoring services function daily. They alert you after your data has been found on the dark web, or after a hard inquiry has been made on your credit.
It still alerts you before major damage is done.
It shifts the burden of vigilance entirely onto the consumer. Comcast fails to secure the data in October 2023. And the restitution is essentially a software tool that tells the consumer, hey, we lost your data, so you better keep a close eye on this dashboard for the next 3 years.
That's a bit reductive.
And historically, the uptake on these free credit monitoring services in class action settlements is incredibly low. Consumers experience alert fatigue. It is a benefit that looks fantastic on a settlement ledger and provides massive perceived value, but offers minimal daily value to a consumer who just wants their underlying data to be secure in the first place.
I'm not sure we can say a $1 million insurance policy provides minimal value. If someone's identity is stolen within that 3-year window, that insurance is the exact safety net you were just arguing was too hard to access in the $10,000 cash tier.
If they jump through the hoops, yes.
It covers the exact friction and lost time you were worried about.
It provides a safety net if they jump through the hoops, to activate the code, monitor the alerts, and then file a highly documented claim with a secondary insurance provider, which just adds yet another layer of administrative burden.
So you see it as just more paperwork.
Exactly, which requires us to pull back a bit. We have dissected both tiers of compensation, the high-friction $10,000 tier and the diluting $50 tier. Now we have to look at the economics of what this structure achieves on a systemic level for the corporation.
It provides a defined remediation for an unfortunate event.
It provides a spectacularly efficient liability shield. Look at the asymmetry of this resolution. In the actual settlement documents, Comcast explicitly denies liability. They admit no wrongdoing.
Which is standard settlement language.
They maintain they did not violate the Federal Cable Act, which has very strict privacy provisions, or any state consumer statutes. They legally maintain that their data security was adequate despite 35.8 million accounts being compromised.
They're avoiding a legal admission of guilt, yes.
And yet, by funding this single pool, they successfully use this settlement to permanently release themselves from further lawsuits.
I see why you view that liability release as a corporate get-out-of-jail-free card. But we have to look at the alternative reality of the courtroom. That release is the fundamental nature of any legal settlement. It is a compromise.
But consider the vast scale of the release. Any consumer who received that December 2023 notice email and does not explicitly file a written request for exclusion to opt out by the summer 2026 deadline, they are permanently barred from ever suing Comcast over this breach.
Right, that's how class actions bind the class.
Even if they do absolutely nothing, even if they ignore the email, never file a claim, never get the pro rata cash, never activate the SciEx Shield, they still forfeit their legal rights. Comcast has essentially purchased a permanent injunction against 36 million potential plaintiffs for roughly $3 a head. all without admitting they did anything wrong.
You're painting the predictability of a balance sheet as if it's a nefarious corporate loophole.
It's a masterclass in corporate liability management.
I defend the pragmatism of the class action system because you have to consider the alternative. Let's play this out. Let's say we don't have this settlement. Let's say Hassan v. Comcast rejects the compromise and goes to trial.
Okay, let's say they do.
A few minutes ago, you literally just argued that it was almost impossible for a consumer to trace their specific data theft to this specific Comcast breach because of dark web aggregation.
It is incredibly difficult, yes.
Exactly. So if it is impossible for a claims administrator to trace it, how do you expect a plaintiff's attorney to prove it to a jury by a preponderance of the evidence?
That's a fair challenge.
The plaintiffs wouldn't just have to prove that a breach occurred. They would have to legally prove corporate negligence, and then prove that this specific negligence directly caused quantifiable financial damages to the class. In data breach litigation, that is a historically insurmountable bar.
The risk of decertification or losing at trial is real. I concede that point.
So the pragmatism of securing a guaranteed $117 million commitment right now, providing immediate, tangible remediation, funding an entire administrative apparatus, and offering 3 years of insurance to anyone who wants it, is a far better empirical outcome than the years-long gamble of litigation. Taking this to a drawn-out trial risks a $0 outcome for all those consumers.
But look at the legal incentive structure that creates. When we accept that the only viable outcome is a settlement structured to protect the corporate bottom line through prohibitive evidentiary standards, we are conceding something massive.
Conceding what?
We are conceding that the legal system is fundamentally incapable of holding corporations accountable for massive cybersecurity failures. Plaintiff attorneys get a guaranteed $39 million. The corporation gets absolute predictability on their balance sheet and zero admission of fault. And the consumer gets a $17 check and an activation code for software.
But they get something.
If the cost of exposing 36 million people's data is just a predictable, insurable line item in a quarterly budget, where is the economic incentive for Comcast or any other massive data aggregator to fundamentally overhaul their security architecture?
You don't think $117 million is a deterrent?
The class action mechanism in this specific manifestation doesn't force better security, it simply becomes the cost of doing business.
I hear your frustration with the systemic incentives. I really do. But we have to evaluate the settlement on its material merits for the individuals trying to navigate it today. Let's summarize where we've landed on the structure of this resolution.
Sure.
My perspective remains that the settlement is a rational, mathematically balanced mechanism. It provides immediate protective services through the 3-year SciEx financial shield for the masses, while maintaining a rigorous, evidence-guided safety net for those who have experienced verifiable out-of-pocket financial harm.
A very tight safety net.
But the rules around documentation aren't there to punish victims. They are the necessary arithmetic to ensure the fund isn't depleted by fraudulent claims. It preserves the capital for the people who need it most.
And my position remains that the very rules designed to protect the fund ultimately alienate the victims it's supposed to serve.
Because of the burden?
Right. The strict documentation requirements, the difficult, fairly traceable burden of proof, and the severely capped compensation for the agonizing reality of lost time. It all prioritizes efficient corporate liability management over comprehensive victim compensation.
We definitely look at the same structure and see two very different motives.
It ensures the vast majority of affected users will fall back to a pro-rata cash adjustment that will likely yield pennies on the dollar, allowing the corporation to basically buy blanket legal immunity without ever admitting fault or facing genuine systemic accountability.
Well, despite our divergent views on the efficacy of the mechanism itself, there was clear ground where we firmly converged today. We both agree that the exposure of 35.8 million accounts represents a critical, undeniable failure in data security.
Absolutely. The scale of the October 2023 breach is just staggering. Passwords, partial socials, it's bad.
And we also agree that navigating the resulting claims process requires a high degree of vigilance from the consumer.
far too much vigilance, in my opinion. Whether a person is trying to compile a pristine dossier of bank statements to claim the top tier, or simply trying to activate their enrollment code before the deadline, the burden of action has been placed entirely on the shoulders of the people whose data was compromised.
Which reflects the broader value of analyzing class action settlements far beyond their headline dollar amounts. When you see $117 million on a news chyron, it sounds like a definitive, massive victory.
It sounds like justice.
But as we've explored today, the true measure of justice and the actual reality of consumer restitution always lies in the granular mechanics of distribution. The administrative deadlines, the documentation standards, the pro rata math, that is where the actual outcome for the consumer is determined.
It is a stark reminder that in the digital age, accountability is rarely a simple equation.
There is much more to explore in the source material regarding the legal precedents set by such data breaches. The specifics of those Federal Cable Act privacy claims and the ongoing evolution of cybersecurity law are entirely worth your time.
Definitely.
We leave it to you, the listener, to form your own conclusion about the fairness of this compensation structure before the August 2026 deadlines. Thank you for joining us on The Debate.